Justin Lindeboom. Very well welcome to Digital Markets Research Hub. You belong to this category of competition law academics who combine their specialism and deep understanding of technicalities of case law with broader understanding of the processes underpinning European competition law primarily, but also American, US competition law, antitrust law. As well as on the top of it, you look at the theoretical issues, which are general and equally important for various areas of law, and thus which continuously feed, inform, enrich our discipline, and obviously indicate their typical problems, turbulences, but also opportunities. So I'm very grateful, first of all, for this chance to discuss some of your ideas. You have published richly in top-tier European generalist law journals, as well as specialist competition law venues. So your views are known, but you have elaborated them on different issues. So I propose we will start looking at competition law as such, and using as a proxy your latest piece in Concurrence 2023, how much economic analysis in competition law and policy do we really want? And the best way would be probably for you to start just highlighting the key messages of this piece.
Right. Well, first of all, thank you so much for the invitation. It's great to be able to discuss to me interesting things with you because as the audience knows, of course, you are also one of the persons who combines one of the few persons who combines theory of law with competition law. So it's great to be here. Yeah, this piece in Concurrence, essentially what I tried to do with it is raise a question which probably many people have asked or are asking, and which you also see in the literature, but perhaps not as explicitly as I try to pose it here, which is what are the institutional but also the epistemic constraints to basically effective and accurate decision making, in this case in competition law. And what I take to be the main sort of intellectual movement or development over the past, let's say, 40 years, but in the EU, maybe 20 years-ish, and these are, of course, crude approximations. The movement is basically towards increasing sophistication within the individual case decision-making process. What do I mean by that? I mean less reliance on formalistic, crude generalizations and increasing attention to the specific circumstances of each case, which are then to be enlightened, fleshed out by initially the competition authority or the other plaintiff, and then to be adjudicated in the judicial process ultimately. And my take in this article is to basically cast doubt or to raise a skeptical voice about this trend of increasing sophistication within the individual case. And I start in the article with a very simple example, namely market definition, asking the question rhetorically almost, is it really the case that the relevant market is a thing which is out there like a natural phenomenon, like a volcano or a planet far away, which we could discover through, sophisticated analysis. And in case we manage not to entirely grasp its nature, it's just a matter of our failure to actually see the world as it really is. So you misapplied basic rules of market definition, or you missed some facts in the world, and that's why you came to a too narrow or too broad market definition. And I think that view is pretty common, at least in adjudication, but I think also in academic literature. And I think it's mistaken for the simple reason that this concept, the relevant market, it's not just that it's a legal concept. We all know this. It's an approximation, it's a proxy, etc. But more fundamentally, it's not the activity of market definition is not something like trying to discover a new planet out there. And there I rely on Magali Eben's, I think, really great article about market definition, where she describes it as not an objective search for something, to be discovered, but a very purposeful activity that allows the decision maker to answer certain questions or to reach certain conclusions. And from that specific example of market definition, I then try to infer some broader conclusions about really the question of, as I said, institutional capacity. How many facts can any authority or any plaintiff or any court really gather? But also the epistemic question. So not just how much time do you have, how learned you are, how much expertise do you have, but really the question of the mere possibility of gathering some facts about the world that will then allow you to reach a certain conclusion about what the relevant market is, or whether, let's say, some conduct is anti-competitive or pro-competitive. And I think especially this epistemic dimension is perhaps, at least is my sense, neglected in recent and also more traditional literature. And in the end, my conclusion, I would say, is that if you accept the premise that there are serious constraints to the epistemic as well as institutional capacity of authorities to sort of find out how much competition there is or what would be the consequences of this or that conduct on competition, then there are very few options left in terms of how to design the system. And one option would be to basically err on the side of defendants, and the other would be to acknowledge, more so than I think what is typically done, a degree of discretion to whatever decision-making authorities are involved. And I think this is a somewhat uncomfortable conclusion, because it basically takes for granted that the accuracy dimension, so the degree to which you can really expect anyone to find true answers, is very limited. Its relevance is very limited, because competition law and policy is not a matter of scientific process, of trying to figure out, against many costs at least, the real answers to the question that you are asking. I think this is probably how I would summarize the main argument.
That's thank you very much. That's very, very helpful and informative, Justin. So I wanted to ask you if you could elaborate further on one of the observations, or rather, implications of this dichotomy, namely your statement that the combination of extensive use of economic analysis by competition authorities on the one hand, and strict standards of judicial review on the other hand, could jeopardize effective competition policy. So we see the trend towards technicalization on one hand, and where do we see it most?
Right. So I think we see it in many parts of competition law, but I think, to two especially important parts are, let's say, recent cases in digital markets on the application of Article 102, and generally speaking, I think for the past 20 years, merger control or judicial review and merger control. And I think also this is a pretty uncomfortable conclusion, if it is right, of course. And I think it's essentially, I don't want to underestimate sort of the actors involved in the process, but I think it is essentially an unintended consequence of other developments. So on the one hand, the recognition that sophisticated, thorough economic analysis is necessary for good, legitimate decision making in competition law has led to a situation where, on the one hand, we rely and want to rely on the expertise of, let's say, the European Commission, for instance, in Europe. But on the other hand, we are uncomfortable in giving them a substantial degree of discretion to actually reach the decisions that they do. So we also want judicial review of those decisions, which is not just a matter of not trusting the Commission, but of course is also a matter of the general constraints that the EU legal order imposes on any administrative decision making, plus constraints by the European Convention of Human Rights. But the combination leads, I think, to a very unfortunate and, in my view, unexpected conclusion or result, rather, namely that the intensive degree of judicial review that we have seen in some cases, including but not limited to the General Court's judgment in CK Telecoms, for instance, requires of an administrative decision-making authority, or is capable of requiring of such an authority, almost the impossible, namely to be able to respond to any or almost any plausible objection to their interpretation of evidence, no matter how complex their investigation has been. And this, I think, is virtually impossible because one of my premises is that there is no level or there is no degree of economic sophistication on part of the primary decision maker that would sort of immunize it from a range of counter arguments. The result, I think, is a situation with a sort of, where you have a sort of contest over economic evidence, which is very difficult to adjudicate, but through very simple and perhaps more crude than we would like to acknowledge rules, such as it is for the decision maker to basically prove its case, or the burden of proof rests with the defendant to show certain efficiencies, etc., which are rules that are much sort of simpler than the initial or than the premises and the principles that underlie the move towards this case-by-case assessment. So I think this results in a very unfortunate situation, which I think is untenable, and will most probably result in a counter movement towards new forms of formalistic or presumptive rules that are basically able to guide us out of paralyzing complexity, which otherwise now informs much of what is going on in competition policy.
Do you think that do you see the solution is counter movements based on formalism, or rather on relativism and realism, or both?
I think that's a very interesting question, and I would say I would say that it is both, but not chronologically at the same time. I mean by that the response, also historically and also outside of competitional, the response to states of the legal system where you have too many, let's say, type 1, type 2 errors, where the conceptualization of legal rules and principles has moved into a direction where you really don't want to be and where you probably didn't want to end up. So, for instance, this could be, excessive reliance on all sorts of economic and econometric theories of harm and competition policy leading to paralysis. But it could also be, if you think of, for instance, the Lochner area in U.S. Constitutional law, a situation where principles of laissez-faire economic policy lead to a jurisprudence of the Supreme Court so much erring on the side of free contract and free labor that it's basically unacceptable politically and judicially. All such developments lead to a counter movement of realism, and the counter movement is we really should take into account different values or different methodological principles. So it's a move towards more inclusion in a way. But inclusion is precisely one of the problems that can cause such a situation. And therefore, I think most, if not all, of the counter movements based on some sort of realism or maybe even relativism, in the end, sometimes very soon, sometimes later, also regress to what I then call formalism. Because in the end, the sort of a Brandeis version of the rule of reason, if we take that as a sort of ideal type, I think virtually everybody recognizes is something unattainable, at the very least, not administrable, and therefore you need certain proxies, certain presumptions, simple rules to operationalize whatever values you want to include into the legal and the judicial process. But of course, once you start getting down that road, inevitably at some moment in the future, you will end up at the same situation where the unintended consequences of increasing rigidity of rules become basically unbearable for that time, for whatever reason.
And another solution to this epistemic aporia is diving deeper into complexity science and borrowing and examining more and more ideas, transplanting them to our field, which would be an understandable response from let's say, academic literature underpinning defendants. But we also see a similar trend from those intellectual agenda setters in the field of competition law, who examine, for example, theory of ecosystem competition, which is very complex and somehow, and it's another. It looks like another attempt, modernistic attempt to confront the challenge in the ever more complex and asynchronous catalog of facts and defenses with even more robust, more sophisticated theories of harm. Do you observe this trend as well, and what are your reflections on it?
I do. I fully agree. I do, of course, observe the trend, and I would say this is an excellent example of this, in a way, realist response to an increasingly formalized application of the law. Most, probably to my knowledge, all of the efforts academic efforts to move towards more complexity-oriented competition law systems sort of juxtapose this view with what they then call something like neoclassical economics, right? Or if they are more critical, they would probably say the neoliberal antitrust consensus. But in any case, they resist and they reject the status quo for a specific reason, which is that it is how I would call it too formalistic. It is too reliant either on simple rules which do not reflect the actual complexity of the world, or they are too formalistic in the sense that they structurally benefit defendants, for instance, right? And then the solution would be, in this case, inclusion of other methods and other worldviews, methodologies like complexity science. I haven't, to be honest, made up my mind fully about the prospects and perils of complexity science in competition law. But what I would like to say is that I don't think generally it can solve the basic value-laden question of who do we want to allocate decision-making responsibility to. So of course you can include all sorts of additional methods, focusing more on dynamic processes of systems rather than static theories of equilibrium, etc., etc. But in the end, the almost too simple to acknowledge question is, who do you want to decide in the first place, and how strict are you going to review that decision? And that's a normative question. It's a value-laden question, and I don't believe it's a question that can be reduced to any empirical model or any methodology of looking at the world. Either you require a competition authority to engage in this sort of complexity science oriented approaches, or you don't. Either you allow the defendants to put forward complexity science oriented defenses, or you don't. So in the end, I think this is not an empirical question, and I think in that sense that the sort of the promises that complexity science and related movements like computational antitrust seem to offer are, in most difficult cases at least, I would guess, not materializing.
And the diametrically opposed solution to this dilemmatic situation was the new competition tool, which has been materialized in the Digital Markets Act and in its UK equivalent, which appears to be an attempt to somehow, or based on the diagnosis or epicrizes which you have just listed in the previous 20 minutes, we can say that could be a very plausible interpretation, or one of several interpretations of how the DMA could make a procedural shortcut and would be a cut in the Gordian knot, essentially, by saying, okay, we grant unlimited, using the proxy of Article 13 anti-circumvention and all these interpretive techniques, which grant an unlimited discretion to the Commission. We decrease the standards of proof. We make them. We grant them an opportunity to cherry pick theories of harm and instances of non-compliance, using draconian methods of remedies, and easing in all the possibilities. Do you see it in this way? And do you think it will last long? Will it last until the first wave of cases, or it will continue?
Yes, I do see it that way, and if you reflect at even some higher level of generality, I see it as a um, as a grant of trust to public authorities to counter alleged power of certain private entities, which again is a very serious normative decision that in other jurisdictions may be politically unacceptable or ethically unacceptable. Whether it will last, I mean, I suppose there are two questions. One is, will this system last in terms of will decisions survive judicial review? Is it really, is discretion, is the court willing to accept this seemingly pretty clear degree of discretion or not? I think it will last in this respect. I see very few opportunities, legal opportunities for resisting this grant of discretion to the commission, as you just described. Will it last in terms of will it deliver the results? I'm in this sense probably as or more relativistic as you are in that my view would be that it's impossibly difficult to talk about this in terms of regulatory effectiveness. Because I take your question also to be, will the DMA be sufficiently effective in opening up markets, ensuring fairness and contestability, so as to basically keep its legitimacy? But then the question is, what would be the state of the world that either confirms or rejects this particular goal? And I think it's really hard to basically answer that question. I think it's incredibly hard to, in 5 or 10 years, evaluate the DMA and or similar legislation in Germany and the UK, etc., and answer the question of whether this is delivering the results. I'm pretty sure that there will be many cases, there are already cases, and there will be many more cases where the outcome of the DMA in concrete cases, like the unbundling to a certain extent of Google search and, let's say, Google Maps, which we are seeing already if you use those services, will be disappointing in the sense either that people say this is reducing the attractiveness and the utility my consumer experience, or in the sense that it doesn't seem to be the case that actually new entrants enter any of the relevant markets easily in the coming 3 years. So I think in that sense, it will probably not deliver in a number of respects, in the sense that there will be many cases where the enforcement of the DMA will not directly contribute to the goals that it is set to reach. But I would also emphasize that to emphasize this point is missing the point, because it's not about the relationship between the goals of the DMA on the one hand and the result in individual cases. I think that view is missing the point, because the DMA's ambitions are not about, in my at least reading, are not about outcomes in individual cases, but are about aggregate results. And in this sense, it confirms again what you were saying initially about lowering standards of proof, providing discretion, trusting the regulator, etc., etc.
This sounds like a music to my ear, Justin. And I want to maybe make a micro, nano amendment to the expectations in terms of aggregate results. I think it would be a further refinement would be needed here, saying that aggregate total results would not be identical to the expectation of deliver comprehensive results. So this total effect is not necessarily about instances of categorical compliance with all possible interpretations, with all catalog of obligations, but rather the result as anticipated by this broader public policy vision. That would be my reading and my kind of peace of mind when I see that the enforcer of this legislation is mindful at least what they want to achieve in this broader strategic perspective, rather than doing this performance measurement by the success of each individual non-compliance decisions opened. I don't know if you would want to reflect upon it, but my central question would be rather, and what would be the implications for 102, at least in the area of digital? Because some people would say, okay, let us acknowledge that you have your toy with the DMA, go on, but this basically reaffirms our position that 102 should be extremely or continues to be very economically complex, and moving forward with this increased standard of proof, because you have an alternative which is completely opposite. Or the other plausible conclusion from this would be, look at the DMA, it manifests a trend, so shouldn't we, it would be kind of schizophrenic to use completely different constellations or visions of world addressing pretty much similar phenomena, or if not identical problems, so to say. How do you read this?
Yeah, I think those are the two options. And so the first option, I take it, is basically the, let's say, the Trinko solution. And the second one would be perhaps, but the analogy is not perfect, but would perhaps reflect the approach of the general court in Google Shopping, for instance. Realizing that we'll have to see what happens, and of course you can only analogize these situations when there's a new case that fully runs concurrently with the DMA. I would refrain from predicting which of the two is more likely, because I think it's a matter of it's not a matter of doctrinal logic that can help us here. Both options seem to me to be grounded in particular visions of how distinct fields of law should relate to each other. You could say, for instance, and this is just sort of thinking out loud, the second option that you mentioned is a little bit Dworkinian, in the sense that it assumes that different but related fields of law, like regulation and antitrust law, should speak with a coherent voice, that they should mutually complement each other, and that they should not rely on diverging or opposing principles, leading to not necessarily inconsistency, but at least an incoherent vision of how law relates to the economy. I think that's an approach that is fairly characteristic of the Court of Justice's jurisprudence. One recent example, which we discussed before, is the DB station case. But in EU law, there are numerous judgments, of course, also beyond competition law, where the Court of Justice seems to reason in this kind of fashion. I would So if I had to bet, I would probably bet on that option, but not with full confidence. And I think it's very well possible that the first option, where antitrust essentially is forced to retreat more, is a very likely possibility, which is based on other but also sound first principles.
And as I mentioned, and as we all know, at the very beginning of this conversation, that you are one of those oracles who enrich competition bubble cluster with the broader reflections upon this. You contextualize it into broader EU law and beyond. But my first question would be about EU law. There is also another issue which I wanted to raise, namely the future of law and economics, legal and economic formalism. But let us put it aside for the moment, because based on what you have answered, I think it would be very helpful for us to understand, zooming out somehow, and to see, are these processes which we experience in our field, are they typical for other EU areas of law or EU sectors? What is the role of competition law? Do we also inform the broader evolution of theory of EU law? And maybe what precisely can we learn from these broader trends? To general question.
Right. I'll give concise answers. As to the first one, sort of building on my previous answer, I think, yeah, you see, I'm not sure whether it's good to quantify this, but I think you see very similar processes in EU competition law as in other general sort of fields of EU law. So, for instance, this choice between the two options about the relationship between the DMA and competition law also is visible in free movement law, where in the early stages of European integration, there was very little harmonization, and the treaty provisions of EU internal market law were interpreted by and large very strictly to basically save the essentials of the internal market. As throughout the decades, we have in the EU harmonized an increasing number of sectors, you can see that the application of the treaty-based freedoms changes too. And generalizing very much, you could say that the approach of the Court of Justice becomes more deferential to member states because if something is harmonized, like food supplements, for instance, you apply the harmonization legislation. And if something is not harmonized, maybe it's because there is no political will to actually regulate this stringently at the EU level. Thus, you see that the Court of Justice applies free movement law more deferentially. So this would actually be sort of, if you analogize again, this would be a sign that could inspire also the second option that you mentioned, with taking antitrust law a back seat. So I think there are all these similarities and analogies between EU competition law and EU law. And of course, this could be for many reasons, but one of the reasons surely is that all competition law cases are decided by generalist courts, sometimes including competition law experts, but even if they are in the room, as it were, they are almost certainly not a majority in the chamber of the court deciding the case. And then the other thing I would like to highlight, what can competition law or lawyers learn from general EU law? I think it relates to this, but I would emphasize the relevance of rules and precedent, which I think is something that, especially nowadays, is perhaps a bit old-fashioned to many competition lawyers. So, why would we rely on judgments from, even if they're fairly recent ones, but sometimes they are from decades ago, not only because they're decades ago, but also because they arose out of very different sets of facts. And I think the reason is, well, this is how the Court of Justice, generally speaking, works. And you may dislike it, there are other ways, but this is no surprise to generalist EU lawyers, as it were.
Let me ask you, Justin, a question about the role of court in these processes, because the Euro-optim or pan-European vision, canonical, Christomatic vision, would somehow position the Court of Justice as a kind of locomotive of European integration, interpreting the vague or open provisions of primary EU law in a very pro-European fashion when the opportunity allows and when the treaties or when the political movement is there, or going backwards when it senses. So it's almost kind of immune system of EU law, essentially, which allows to shape its contours and then reaffirmed backwards in the primary law itself, some principles discovered, invented, or articulated by the Court of Justice. And moving backwards to its position towards one or two cases, it's post guidance 2008. Is it somehow in dissonance with the broader trend? And if it is, what does it tell us about this maybe naive or very too simplistic vision of the Court of Justice as a locomotive of European integration? Or maybe it tells us about our understanding of EU integration being rather pro-defense, as opposed to considering the Commission as the main actor in these processes.
Right. That's an extremely interesting question. I cannot most likely give a fully satisfactory answer, but how I look at this post-guidance case law, and of course we talk about it in terms of the more economic approach, etc., etc. Though I think the most substantial movement only really materialized with the Intel judgment. So that's actually that's pretty long way down the road. But there were signs before that as well. And I think how I like to see this judicial trend is as a response to a consensus or seeming consensus between regulators, authorities, public authorities, and those regulated. So let's say companies, attorneys, etc., etc. I think around 2008-ish, even as in the broader economy, with the financial crisis, with the Occupy Wall Street, etc., etc., there may have been increasing skepticism about maybe economists or technocrats, etc. I think at that moment in time in EU competition law, we didn't really have that degree of skepticism. Rather, we had a consensus among all those involved that this, let's call it a neoclassical economically informed approach to competition law, is the way to go. And I wasn't in the room when, let's say, post-Denmark was decided or when Intel was argued, but I'm pretty confident that this consensus, at least about the methodology and what we expect of administrative authorities, was also very much visible in the room, because it was visible everywhere, including in the academic literature and in policy circles. And I think that explains why the court went along with this road, even though this development was arguably a rupture from, let's say, some of the classic approaches in EU competition law. Whether this will last remains to be seen. But I think this explains at least what has happened so far.
And continue within this topic, but looking at it from a different perspective. One of your latest projects, major projects, autonomy of EU law, legal theory, and European integration, co-edited with Ramses Wessel. Amazing collection of papers, very rich and informative, published by European papers, Journal of Law and Integration, open access. As far as, or maybe my settings allow me open access. I wanted to ask you about this large project, and the next question will be about the project which you do with two of our great colleagues, Elias Deutscher and Stavros Markis. Maybe you can combine if they are combinable, or maybe you would prefer two separate answers.
No, I would give one answer, and the answer would be that both projects, so the special issue, which is already out, and the book project with Elias and Stavros, are basically came out of my interest, which I also take to be one of your interests, and there are others, about the interaction between at least legal theory, maybe economic theory and other theory as well, but at least legal theory and, let's say, legal doctrine. The autonomy of EU law special issue was an attempt to combine two worlds, which, although they seem to be able to learn a lot from each other, have been separated for a long time. That is, legal philosophy on the one hand, and EU law, including EU constitutional law, on the other hand. I think the expert communities in those fields simply don't really talk to each other as much. And this was an attempt to bring together those worlds for a bit, with legal philosophers who ordinarily don't really think about EU law or write about EU law that much, to offer their perspectives on EU law, but also EU lawyers, EU constitutional lawyers, sort of trying to think about what EU law means for broader legal theory in general. And the book project with Elias and Stavros quite similarly tries to link theory, legal theory, but also economic and social theory to competition law, and to sort of try to think about what those can learn from each other, how various forms of theoretical analysis can shed light or perhaps obscure parts of competition law in a way that that is at least insightful to some degree.
Three last questions. The first one is about the piece which you have published in this co-edited volume, referring us to 19th century US constitutionalism, and you tried to somehow to extract some important takeaways for the situation which EU constitutional law and policy is currently in the 21st century. Can you reflect, please, upon this?
Yes. So comparison between the United States and the European Union is, of course, not new. As you know, and as many EU lawyers know, the early efforts to theorize EU law were interestingly done by Americans rather than Europeans, like Eric Stein, and people at Michigan University. Nevertheless, I think that there are certain hidden parts, both of EU law and of US law, especially US law in a historical perspective, which could really provide new insights, comparative insights, but which haven't really been analyzed that much. And this specific piece is about one such area, namely conflicts between state power and federal power, or in the EU, supranational power. And I learned about this when learning about general US constitutional history, especially the early 19th century, so really the first decades of the American Republic. And what struck me is how, at a very detailed doctrinal level, the discussions that were happening at the time are basically just being reenacted right now. So in May 2020, we had the German Bundesverfassungsgericht's judgment setting aside a judgment of the European Court of Justice, which was sort of maybe expected, or at least it wasn't unprecedented, at least as a threat in EU law. But what I guess fewer people know is that exactly the same types of declarations of ultra vires, very strong debates between Supreme Courts at various levels also took place in the early 1900s, early 1800s, sorry. And I think it was interesting and maybe also worthwhile to look at those very early judgments and see perhaps whether they can teach us something about what's happening in the EU right now.
And I wanted to apologize, Justin, because the last three questions appear to be unrelated to each other. But now I see that I somehow can connect my next question to the previous one. Namely, we see the literature, the emergent strand in EU and more theoretical corners of these discussions, the attempts to use the vocabulary of empire. And I refer less to digital empires of Anu Bradford because they are more known for DMA-oriented cohort, but more to constitutional matters by Signe Larsen, for example. It's not in the newest piece, but in 2020 is published in European Law Life, where the vocabulary itself is quite telling, but also maybe if you can reflect upon this. The implications of use and what does it tell us about the ambition of EU constitutional orders in terms of building up something obviously sui generis, but looking at US constitutional tradition and looking at normatively as a kind of end goal. And the second aspect of this question is more substantive in terms of DMA objectives, which we have referred to earlier in this conversation, and which it appears to me that we somehow see the broader mandate, or one of the possibilities of the broader mission of the DMA in a more or less same direction. Do you think in order to deliver on this to increase the competitiveness, to increase the digital muscles of Europe, we would need looking at it as empire in this 21st century, as in economic sense, etc.? How do you see these processes?
Right. Those are very challenging questions, but also very interesting ones, of course. I think the vocabulary of empire, and you refer to the two sort of exemplifications of this, is used in very different ways. So on the one hand, Anu Bradford and her work on digital empires, I suppose is a fairly descriptive attempt to explain certain things, while Larsen and others, when they talk about empire, I think the explanation is at least to a large extent more critical. It tries to unveil certain processes, in some cases maybe a certain agenda that is not always transparent and sometimes quite clearly hidden. And there, the word empire also has the connotation of maybe unjust or let's say unjust expansion, subjugation, and power in a fairly negative sense. I think depending on how you use the word empire and which sort of vocabulary and which tradition you are positioning yourself in, you're able to explain different things. So when it comes to very simple things like primacy of EU law, the supremacy of the US federal government, basically the to sort of paraphrase Garrett Davies, one of the great EU lawyers today, it's about humiliating the state, either in the US or in the EU. That's a way to use the term empire and the vocabulary, which I think can be very productive and enlightening, but which does expressly take this critical approach, works within a critical discourse. When it comes to the DMA, Bradford's work on digital empires, etc., I think it's a different discourse. It can be very critical, but the basic objective is to describe rather than to critique. And in that sense, it is equally important, not just theoretically, and I think Bradford's work has great theoretical merit, but also doctrinally, because in the end, we're mostly talking about very abstract and to us probably at least very interesting topics, but in the end, it's also a matter of legal doctrine, and it's also a matter of simple and at the same time, very complex questions like extraterritorial application of the merger regulation, for instance, right? So it's exactly, again, this intersection between doctrine, legal practice, and the resulting political conflict that may arise from it. But on the other hand, this theoretically robust models that try to explain what's going on. And I think this vocabulary of empire has really enlightened, at least in these areas of law, what's going on. So I'm really interested in that. I haven't really contributed to this discourse myself very much, but I recognize the immense value of those contributions.
Thank you very much, Justin. And the last question before reverting to recommendations to students moves us back to the first cluster of topics, legal and economic formalism. We see you have published in Oxford Journal of Legal Studies, and you reflect upon these issues for quite a long time, actually. What I wanted to connect this question while asking you also to reflect if you want to maybe to highlight the key takeaways from this piece, which we have not been discussed yet, but also we remember the kind of neoclassical economic consensus about the role of the omnipotence of law and economics to explain and even normatively underpin the complex world. And now we see quite often this, perhaps in many respects, excessive enthusiasm of equal degree to criticize it comprehensively and somehow diminish, marginalize its role in antitrust as the main toolkit, analytical toolkit at least, by different cohort of people nihilistically somehow refuting it. Do you see how do you reflect upon these processes? Is it inevitable? Is it necessary? Or maybe we can overshoot the mark with this?
I think all of those are true. So I think it is, if you take a step back and you try not to engage with the, let's say, the substantive debate itself, which sometimes is pretty hard, especially if you have strong opinions, but I think it is a phenomenon. So the critique of neoclassical economics, the very use of the term neoclassical economics, of course, I admit that I use the term too, but I also recognize that this is a term that you partly use when you are within the paradigm itself, and there are exceptions to it. But it's a term of critique. It is understandable. It is also, I think, necessary. We've been talking about this, the degree to which any sort of knowledge system or any approach to, in this case, law, is prone to lead to formalization, and thereby also at some moment inevitably loses its capability to either explain the world or prescribe outcomes that are taken to be legitimate. So in this case, neoclassical economics, in the sense of the way that we have been applying competition law for the past 40 years, roughly, is, I think, at this stage, regressive, in the sense that the costs of looking at competition law this way are increasingly outweighing their benefits. Therefore, the counter movement is necessary. Are we then overshooting the mark? Are we criticizing neoclassical economics? Are we criticizing economics too much? Probably the answer to that would be yes as well. And you can look at this with the glass half full or half empty. I look at it half full, because I think that out of this contestation, where both sides, if you look at it like this, are probably overshooting the mark, in the end leads to a new equilibrium, which may not be better, is likely not better than the previous one, but is more suitable for that time. The 1970s required a different way of looking at the world than the 2020s. And it is only through exchange, if perhaps pejorative, maybe too pejorative at times, that we develop a new way of looking at competition and competition law that is suited for our times. So in that sense, I am agreeing with all of your qualifications and maybe critiques of the critique on neoclassical economics, but I think it is a necessary and ultimately productive route that we are taking.
Amazing. Let us now revert to the recommendations to those who wanted to join the profession in this very interesting time.
So I think my main recommendation, which is a very general one, is to try to be an insider and an outsider at the same time. I consider myself, at least, probably to be a little bit more of an outsider within the competition law world than an insider, because it is, not my most natural field of discipline. But it is important to be at least enough of an insider to be able to communicate with others. So you need to know the doctrine, and that's pretty easy because if you're a student right now or you're an aspiring competition lawyer, you are forced to learn the doctrine. But I think it is really important to really force yourself to become an outsider as well. And this can be done very easily simply by reading things outside of your field, and even, which is a bit more difficult, to read outside of what is necessary. Especially as you get busier, at least that's my experience, that becomes increasingly difficult because there isn't much time, if any, to read for, let's say, general education, as your formal education has ended. But I think it is really important to nevertheless try this, and to immerse yourself in fields of interest which are not, or maybe just marginally relevant to your primary discipline. And this could be anything. This could be philosophy. This, as you have done, for instance, you wrote a book, among others, on in which you combine exclusive legal positivism and other areas of legal philosophy with competition law and its goals. And you could only do that presumably because you were interested in that legal philosophy. But it's not straightforward to try to look for those connections. You really need to push yourself. So it can be philosophy, it can be sociology, it can be a complexity science for that matter. But broaden your scope and try to be a bit of an outsider, even if you're working on the inside. That would be my main recommendation.
Justin Lindeboom, thank you very much indeed for this fantastic, very informative set of ideas which you shared with all of us.
Thank you so much.